Welcome to This Explainer. Today, we're diving into the highly complex geopolitical situation in the South Caucasus. Specifically, we're looking at Iran's legal standing in the Zangezur question. But we're going to do something very specific here. We're stepping completely away from the political noise, the daily headlines, and all that regional posturing. Instead, we're breaking this situation down strictly and objectively, using the rigorous framework of international law.
To pull this off, we're drawing directly on a comprehensive analysis by Dr. Salar Safodini. He's a South Caucasus expert with a PhD in geopolitics. Our main goal today is to bypass all the political rhetoric. We are focusing exclusively on the nuts and bolts of international law to understand exactly how the rights of neighboring states are defined and legally protected when regional borders are negotiated.
Okay, so here's our legal framework agenda for today. We'll cover defining post-Soviet borders, rights of third-party states, the indispensable party doctrine, the principle of equity, and finally, the good faith mandate. Let's just jump right in. Section 1, defining post-Soviet borders. You see, any legal analysis of this region really has to start with the baseline rules governing territorial integrity. So think of the 1991 Alma-Ata Declaration as sort of a giant geopolitical reset button. It basically established the legal basis for recognizing the borders of post-Soviet states, relying entirely on the former administrative divisions of the USSR. From a purely legal standpoint, when nations in this region reference this declaration today, it acts as this foundational mutual acceptance of existing border demarcations. In theory, this is the exact legal mechanism meant to put an end to further territorial claims and ultimately prevent border instability. Moving on to Section 2, rights of third-party states. Now, what actually happens when two states sit down to negotiate a transit route or a border issue, and those negotiations directly impact a neighboring third-party state? Well, it might surprise you to learn that protections for third-party states aren't just made up on the fly for modern disputes. They have incredibly deep, established historical roots in international jurisprudence. We're talking decades of established treaty law and major international court rulings. The absolute bedrock of this is Article 34 of the 1969 Vienna Convention on the Law of Treaties. Let's look at this fundamental principle directly. No international agreement can impose rights or obligations on a third state without its explicit agreement. I mean, this is a total cornerstone of international law. A treaty between State A and State B simply cannot bind State C unless State C explicitly gives its consent. This brilliantly illustrates a concept that actually originates in ancient Roman law, which really just goes to show you that lawyers have literally been arguing over borders for millennia. On the left, we have your standard bilateral treaty, which is binding only on the people sitting at the table. On the right, we have the Latin legal maxim, res inter alios acta. Now, in plain English, this just means a matter transacted between others does not harm or benefit a third party. So legally speaking, a contract negotiated between Armenia and Azerbaijan cannot lawfully inflict harm upon a third party, like Iran. Because of this rule, international law grants neighboring states what is known as a formal right of objection. If two states are negotiating a corridor that threatens vital national interests, transit routes, or border security, that third state has the absolute legal right to step up. They can voice their opposition through diplomatic channels, issue formal protests, and totally insist that their concerns are addressed. Which brings us to Section 3, the indispensable party doctrine. But hey, what if those diplomatic objections are just completely ignored? That's exactly when the legal framework shifts from diplomatic shields to legal swords. This introduces the principle of the indispensable party. You might remember the 1995 East Timor case at the International Court of Justice. Well, that case famously proved that if you try to resolve a dispute and that resolution substantially affects the legal interests of a third state, that third state absolutely must be included. If you exclude a vital third party from the proceedings, the entire judgment or adjudication is legally invalid. Without their inclusion, no legitimate judgment can be rendered, period. So the crucial point here is that this leads directly to the doctrine of the conditional right of intervention. Now, just to be crystal clear, outright interference in another state's internal affairs is strictly prohibited. However, when vital national interests are put at risk by an outside bilateral agreement, the affected state is legally justified in undertaking diplomatic or non-military actions. We're talking things like conducting border maneuvers, issuing formal warnings, or invoking regional mechanisms to safeguard their own national security. All right, Section 4, the principle of equity. As we move into this section, it's important to realize that international law doesn't just provide rules for intervention, it actually provides overarching behavioral guidelines to ensure fundamental justice. Enter the principle of equity, which is explicitly enshrined in Article 38 of the International Court of Justice Statute. Think of this as the ultimate legal standard for fairness. It is used heavily in disputes over shared resources or tripartite conflicts to ensure that the outcome isn't just some technical loophole, but is fundamentally just for everyone who is exposed to the geographical changes.
When we apply this to Dr. Seyfoudini's core thesis, equity legally justifies Iran's involvement in the Zangezur question based on three key factors. First, the geography. Iran shares over 40 kilometers of border with the Zangezur region. Second, the principle of direct effect. This basically says any state facing tangible harm to its trade or security from an agreement must be granted the right to participate. And third, the strict prohibition of unjust exclusion, cutting the most geopolitically exposed actor out of the decision-making process that directly violates the core principles of international equity.
And that brings us to Section 5, the good faith mandate. This is our final legal principle, and it dictates the very nature and intent of how states must act when they draft these treaties. The principle of good faith. Now, this isn't just a polite suggestion, it is a strict legal mandate, found right in Article 2 of the UN Charter and Article 26 of the Vienna Convention. It absolutely requires that states conduct their negotiations, interpret their treaties, and exercise their rights honestly, fairly, and without any manipulative intent. Let's actually contrast how this looks in practice. Good faith, in the context of transit, means genuinely opening routes in a way that respects mutual communication for all neighbors. Bad faith, on the other hand, involves superficial or, well, manipulative treaty structures. You literally cannot claim to draft a peace plan aimed at opening transit routes if the treaty is maliciously structured to block a neighboring state's existing communication corridors just to achieve geopolitical containment. That is a flat-out breach of international legal obligations. So, we've systematically traced the laws of territorial integrity, third-party rights, indispensable participation, equity, and good faith. But as we wrap up this explainer, I really want to leave you with a crucial question to consider as you watch the news out of the South Caucasus unfold. Can these textbook, decades-old international legal frameworks actually withstand the massive pressure of modern, rapidly shifting geopolitical maneuvering? It's a fascinating tension between established law and modern power dynamics, and understanding it is absolutely key to decoding the region's future. Thanks so much for exploring this with me today.